program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, we always have a packed agenda of issues to discuss. Tonight is no different. I want to begin by welcoming our viewers who are joining us on television from region number 5 and region number 6. Welcome to another program of Issues in the News. To our listeners who are joining us from Freedom Radio, Rob Street, Georgetown, welcome. And last but not least, to the tens of thousands of you who are joining us on Facebook Live across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, and beyond. Welcome to another program of Issues in the News. Please share this program so that all your friends and all your followers can join us in tonight's discussion. Press that share button on your phone, on your iPad, on your computer, on your laptop, on your desktop, or whatever instrument you're using to view this program. Share it. Share the live so that all your friends and all your followers can join us in tonight's discussion. We want the widest possible audience joining us. And I want to welcome Rashid Inderdat, Pam Singh, Diona Nan Suku, Omar Sharif, Mohammed Rashad Khan, Abdul Rashid Sattar, Sean Scott, Colin Singh, Biki Kumar, Indra Sanchara, and so many of you who are already on Facebook Live joining us for tonight's discussion. Use the comment section to ask questions, raise issues, and ask for any issue that you want clarification on. I want this program to be interactive. So ask me questions, raise issues, and as far as possible, I will try to address them because I want to engage you on this program. So let's begin. Last week, as you would have observed in the media, I had a very important meeting with important operators in the banking sector. This meeting came about upon the instructions of His Excellency the President, who met with the banking officials the day prior, and some very crucial issues were raised of a legislative nature. And His Excellency asked me to engage the banks and to address the issues that they are complaining about. And we had the meeting, and it was a very fruitful engagement. A number of issues of crucial importance were raised, and as far as possible, we attempted to address those issues. Accompanying me in that engagement were my colleagues in Cabinet, the Honorable Colin Crowell, the Honorable Suzanne Rodriguez, and the Honorable Vanessa Ben. As I said, a number of crucial issues were discussed. And I had another program, an interview on a program called Starting Point with Kiana Wilborg, and the discourse continued in relation to the matters that were discussed with the banking officials, and it created quite a lot of momentum in the public domain, and that interview was carried widely in the press It generated a lot of discussions and a lot of interests. And I'm grateful, and I want to begin this program by continuing that discourse which I had with the banks. So one of the issues that arose in our engagement with the banks related to access to financing. And one of the crucial issues that we had to confront was the fact that we enacted a legislation called the Security Interest in Movable Property Act, number 20 of 2024. Now, this piece of legislation introduces a modern framework for the registration of security interests in movable property and represents a significant milestone in advancing Guyana's business and financial regulatory environment. Under this act, persons can borrow using movable property or chattels as security, in particular if they are borrowing to purchase these movable properties or chattels. This is largely done by hire purchase agreements as well as bills of sales or other forms of credit sales or credit transactions. And this new legislation allows a modern framework to be established. It provides for the establishment of a special registry within the Deeds and Commercial Registry called a collateral registry. And these credit instruments are filed as of record at this registry. And as I said, this legislation allows for persons to take out credit or buy these movable properties on credit using the very movable properties or other movable properties as collateral for the credit transaction. And the different instruments, of course, different instruments can be used to secure the credit that is given. And these documents are filed at the collateral registry of the commercial registry. That registry was not up and running because of some technical difficulties. I am pleased to announce that as of today, the registry is up and functional, and bankers, retail suppliers, automotive dealers, and all those businesses engaged in selling movable property on credit can now have access to this collateral registry and file the requisite instruments which they will decide to use to secure their credit. The Bill of Sales Act has been repealed, and this new act will substitute for the Bill of Sales Act, because one of the most popularly used credit instrument in these credit sale transactions is a bill of sale in relation to movable properties. So many of you, when you purchase a car from an auto dealer on credit, you either do so by hire purchase or you do so by an agreement of sale, but the monies outstanding on that motor vehicle is secured by the execution of the vendor of what is called a bill of sale. And by that instrument, you owe the owner the amount of money outstanding, and that bill of sale contains the conditions in relation to how you will repay that debt. And the vehicle or the subject of that bill of sale, which is the collateral for the bill of sale, is the collateral. And if, for example, there is non-payment or there is some breach of the bill of sale agreement, the creditor is entitled to the remedies that are contained in that instrument, which may include repossession of the chattel or the movable property. So you have a modern framework now through which you can access financing, and the banks and the auto dealer and the businesses who are engaged in these transactions now have a modern framework within which they can transact their businesses. This is not financing, this does not deal with financing for immovable property. I spoke at length on that issue on the Starting Point program. And I said that there's a different regime. And as I said then, and I reiterate now, I did not find any provision in our laws which mandates the use of immovable property only as a collateral for lending. I think I made that point, and that point is, I see it being reported all over the news. I stick by that position. But here we are dealing with movable property being used and a modern regulatory framework established. I have asked the Registrar of Commerce to issue a notice that will be published informing all stakeholders of the now functioning collateral registry, because it was not up and running since the Act came into force, and that created some problems. We have addressed that, and there's a whole mechanism now in place that allows for the use of this registry. Stakeholders, both on the banking and on the commercial side, were trained in relation to the use of this registry, and of course the registry staff themselves were also trained. But we undertook at that meeting that we will follow up with more training, because the issue was raised in relation to more training to familiarize all the important stakeholders and players involved, familiarizing them with the provisions of the Act and how the registry will function. So that's the first issue that I wish to deal with. Last week we had in Guyana the President of the Caribbean Court of Justice He was here to witness and be present at the swearing-in ceremony of the latest addition to the court, Mr. Justice Arif Christopher Bulkan. As we all know, Justice Bulkan is Guyanese by birth and was elevated to the Caribbean Court of Justice by his appointment by the Regional Judicial Service Commission. And the protocols are that the oath of office is taken before the head of state of the country from which the judge emanated. Arif Bulkan is Guyanese, so the oath had to be taken before President Dr. Mohabir. And the President of the Caribbean Court of Justice paid a courtesy call on me, as he did on other important state functionaries, including the opposition and, of course, His Excellency the President. And in discussions he had with me, he raised the issue of the lack of support that the Caribbean Court of Justice is suffering from in relation to other member states of CARICOM. And I believe that Guyana has a duty to try to influence other members of CARICOM to sign on to the appellate jurisdiction of this court. So far, Guyana, Barbados, Belize, Dominica, and St. Lucia are the only Caribbean territories that have signed on to the court in its appellate jurisdiction. All the other countries have signed on to the court in its original jurisdiction. Let me explain quickly the difference between the two. The original jurisdiction of the court is the jurisdiction that the court has to adjudicate on matters arising from the Treaty of Chaguaramas and other regional agreements. The court has a treaty jurisdiction and is the forum where disputes arising from these international regional instruments can be judicially ventilated. So that's the original jurisdiction of the court. The appellate jurisdiction of the court is where it sits as the final court of countries that have adopted it as its final court. Like in Guyana, we have adopted the court, and we were one of the first territories to have adopted the court as our final court. So cases starting in Guyana can go from the High Court to the Court of Appeal to the Caribbean Court of Justice, and that's where it ends. Only those countries that I've mentioned earlier have signed on. So most of the independent Caribbean territories have not signed on. And that's a travesty. We often speak about regional integration. We passionately pursue regional integration. We passionately pursue our rights as sovereign nations. We passionately pursue issues such as regional unity. We passionately pursue issues such as the creation of a common single market and economy. And here it is that we can't get our acts together to support one of the most significant regional institutions in the Caribbean Court of Justice. There is hardly another institution of greater significance than the CCJ. And countries in the Caribbean who are otherwise the champions of regional causes are not signing up to the most premier regional institution, the CCJ. It's an oddity that some countries still prefer, in the year 2025, 6 decades after, or 7 decades, 6 or 7 decades after they have attained independence from Her Majesty's government, continue to cling to an institution that is of a colonial creation, Her Majesty's Privy Council. And that remains an oddity. It flies in the face of Caribbean integration and regional unity. The seat of the court is in Trinidad and Tobago, and Trinidad and Tobago has not signed on. Now, no one can force a sovereign government to join the court. But we have to exert more efforts in getting countries in the CARICOM region to sign on to the appellate jurisdiction of the court. I don't think one can fault the quality of jurisprudence. The quality of judgments emanating from this court can hold its own against any courts of similar jurisdiction. I have had the honor and privilege of appearing before the court as a lawyer in private practice. I have done so as Attorney General. I have appeared in the appellate jurisdiction of the court. I have appeared in the original jurisdiction of the court. I have appeared in other international tribunals of high standing. I just came back having appeared in the International ICSID at the Arbitration Center of Paris, the International Center for this ICSID, I think International Court for the Settlement of Commercial Disputes. I appeared at the International Court of Justice, the ICJ, and the Caribbean Court of Justice can stand and hold its own with any of these international tribunals. So it's really an enigma, and that it is not winning the support of the rest of the Caribbean. And we have to all work to change that. We know the value of that court to Guyana. Imagine what would have happened in this country if we did not have a Caribbean Court of Justice. So we know the value of the court. And that court will continue to be of extraordinary importance to the people of Guyana. And we have to ensure the survival of that court. So, this case, what was the name of this party? Forward Movement Guyana? Forward Guyana Movement. This party has filed another legal challenge against the 2025 elections. You would recall that in the name of Crystal Fisher, it filed a legal challenge against GCOM and the Attorney General 2 weeks before the September the 1st general elections. The case was heard and dismissed and described as being without merit and an abuse of the process of the court, and costs were awarded to the respondents in the sum of $1 million each. Rather than express some degree of contrition, they moved to the Court of Appeal. They filed an appeal to the Court of Appeal. 3 judges sitting in that court expressed similarly condign views and dismissed the appeal. They got another order of $1 million cost against each respondent. So they are at $4 million. Again, not being satisfied, they attempted to file another appeal to the Caribbean Court of Justice. They did not get the procedure right, and the CCJ rejected the alleged appeal. They do not know that you have to get leave of the Guyana Court of Appeal before you can go to the Caribbean Court of Justice. That basic procedural requirement, they don't know. So they went straight to the Caribbean Court of Justice, and the Caribbean Court of Justice rightfully rejected their attempts at filing an appeal. So they are back at the Guyana Court of Appeal seeking leave to appeal a decision of the Guyana Court of Appeal to the Caribbean Court of Justice. While that application for leave is pending and not being satisfied with the series of adverse rulings that they have received, they now file what they are describing as an elections petition. And they have filed this alleged elections petition in the name of one Randolph Critchlow. Now, Guyanese population, the Guyanese population is not unfamiliar with elections petitions. You know that it's a special type of litigation. You know the rules and procedures governing elections petition are of a unique type. They are called peculiar. They are called extraordinary. They are called sui generis. They are special. You know that if there is any flaw, either in the form of the petition, or in its substance, or in its procedure, that flaw is fatal. It's not like an ordinary case where a flaw or a deficiency can be corrected. In elections petitions, any rule of procedure that is breached, any deficiency in relation to form is normally fatal, and the petition will be dismissed. And that is how petitions have been dismissed repeatedly in Guyana. And these matters have gone all the way to the Caribbean Court of Justice. And the Caribbean Court of Justice have upheld these sacrosanct and sacred legal principles. Why? Because you can't detain the formation of a government. An elections petition questions an election. If you question an election, it means you're questioning a government. You're questioning the composition of the parliament of a country. And if you want to challenge those mighty institutions, and you want to put a government and a country in jeopardy, then you must come good, for want of a better word. You must put all your ducks in a row. You must get all your cards right. This type of litigation does not permit mediocrity. It does not permit mistakes. It does not permit errors, genuine or non-genuine errors. Once you err, you go. That is the nature of this law and this jurisprudence. Well, this thing that they file, that they're calling an elections petition, is not an elections petition. When you look at what an election petition looks like, it is not this. They just title it elections petition, and they think that is an election petition. And they have violated almost every rule and every procedural requirement surrounding the preparation and filing of an election petition. They have violated every rule and every requirement in relation to the preparation, that's the form of the petition, and its filing. There are many rules governing how this thing has to be done. All of it have been violated. And the court will now have to deal with another colossal abuse of its process. The parties who ought to have been named by law are not even named. But I don't want to go into all the arguments here. What I'm saying is that this petition is hopelessly misconceived and woefully deficient. And one can predict with almost virtual certainty that it will be dismissed. The Attorney General has been named as a respondent. GCOM has been named as a respondent. The Attorney General is already preparing an application to strike it out. I don't know what GCOM's position is, but more likely than not, it will be the same thing. Whatever, you cannot get a case more wrongly done than this. And this time around, I support people challenging decisions in the court or challenging important events in the court. It's part of the rule of law, it's part of democracy, it's part of one's freedom. But one must do so diligently and competently. As I said, this is a colossal abuse of the process. And at the appropriate time, an application will be made for costs against counsel in this matter. An application will be made for costs to be paid personally by counsel, not only by the litigant, but by the counsel. The leader of this party is a lawyer, and clearly, the leader of this party, I don't think, has ever seen an elections petition. Because what was filed there would not have been filed. And at least some of the rules would have been complied with. Here, none of the rules have been complied with. And the document that is filed cannot be described or characterized as an elections petition. You can't just call something an election petition and it becomes a petition. Can you just look at an aeroplane and call it a motor car and it becomes a motor car? So that's what we have to deal with. But we will deal with it. So that will be heard. Our application will be filed as soon as possible, and hopefully we get a hearing early and we are able to ventilate this legal proceeding. I don't want to say a petition because, as I said, it doesn't look like a petition. I don't know what it is. The court will determine what it is. And as I am on GCOM, many persons have been asking me to comment on the issue in relation to the opposition members on the commission. I see in the news that the chair of GCOM has taken a particular position in relation to those members of the commission. Well, remember earlier this year, the commission had solicited my advice, my views on a particular matter in relation to laws that the Attorney General Chambers drafted. So there was nothing wrong with my views being solicited. And I was not advising GCOM as their legal advisor. But every Tom, Dick, and Harry Lau jumped on my back and said that I am advising GCOM and that's wrong and that's incestuous and there's a conflict of interest and all manner of accusations they made against me. So I will refrain from expressing a view on the matter. I have my views, obviously. GCOM is an autonomous body, an autonomous independent body, and the chairperson has taken a position. This obviously is a legal issue involving the opposition, and they have to resolve it. It's obviously a constitutional controversy, and if it reaches the court, in any event, I will have to be a party because all constitutional matters require the Attorney General to be named as a respondent. So I should not be speaking on this matter in any event. If it reaches the court, And those who are aggrieved obviously must know that they have recourse to the court. It's a legal issue. And they can have the matter ventilated there. My views will be expressed at that forum. I don't think it's necessary for me to be dragged in an opposition dispute or to comment on the independent exercise of GCOM's prerogative on a matter that concerns GCOM. So those are my views on that issue. I know the press, many reporters have been calling me and messaging me on my views on that matter. So I pause here to look at your comments. Let me see. Yeah, somebody said the leader of this party, along with her attorney, probably studied law at Azruddin Mohammed University. Well, I guess the person is being facetious. So you see, I'm looking at your views, and I am. Please don't use indecent language on your comments. I'm seeing people getting annoyed and cussing up and so on. I know it's sometimes you get angry and you get frustrated, but please control. Let's be decent and civil in our disagreements. You know, oftentimes we have said that Guyana is leading on many fronts in the Caribbean. And indeed, we are. On climate change, on the environment, on the energy sector, and we are also leading on the legislative front. I have often said that we have, by far, the most aggressive legislative agenda in the region. And in any given year, we enact more laws than any other territory in the Caribbean. And that is being recognized throughout the Caribbean, not only by governments of the Caribbean, but by the international financial agencies. So the Inter-American Development Bank, along with the government of Barbados, is hosting a regional high-level symposium to advance state response on domestic violence in the Caribbean. And this engagement will be held in Barbados next week. Attorneys general from across the Caribbean will be in attendance. Also in attendance will be commissioners of police, heads of gender bureaus, other ministers of the government, our Dr. Vindhya Prasad, Minister of Human Services, will be in attendance, and senior technical officers from 18 CARICOM member states will be present to participate. And Guyana, and this is the IDB letter inviting Guyana, and this is what the letter says. Guyana has demonstrated true and thorough leadership for the region in the areas of domestic and sexual violence legislation and policy. It would therefore be an honor to have your presence at this symposium, to participate in a panel of your peers, etc., etc. So we are recognized by the IDB for our work in these important areas, policy work as well as legislation. Guyana has demonstrated true and thorough leadership for the region in the areas of domestic and sexual violence legislation and policy. And it will be an honor, therefore, to have your presence and to have you participate, etc., etc. Sometimes we must recognize the hard work that we do. Because sometimes if you don't recognize it, nobody will. Next month, again, Guyana has been invited to two important conferences dealing with law and legislation in the Caribbean. One is a conference by UNDP, where the issue of violence as a public health hazard in the Caribbean will be discussed, and another important conference that will be hosted by the CCJ Academy for Law. That's the academic arm of the CCJ. The CCJ Academy for Law is holding another symposium in Trinidad, and Guyana has been identified again as main presenters, as one of the main presenters at both of these conferences. Why? Because of the work that we are doing legislatively and policy. In fact, the symposium that's being held by the CCJ primarily focuses on how governments can assist in the rule of law, its enforcement, and judicial development. And Guyana is being looked at again because of the crucial role the executive is playing in nurturing and advancing the rule of law and in resourcing the judiciary. I said on the same program starting point that our most ardent critic will have to concede that the judiciary of Guyana has never been resourced in the manner in which it is being resourced now. Never in its history. And we are seeing the benefits of these investments. We are seeing investor confidence in the economy. We are seeing the public trust in the judiciary increasing. I can boastfully say that we have managed to almost successfully, we have managed to almost eliminate the decades-old backlog that has burdened the High Court for so many years. I said recently we have a backlog at the Court of Appeal, but we now have 11 judges there, and hopefully that will be aggressively tackled shortly. So we have made tremendous strides in improving the legal sector and the judiciary in this country. The government has invested heavily. Whether you want to talk about the e-courts and the mobile courts that we established, I think 28 of them during COVID. 28 of them, and they are still running. And then look how many new courts we have established across the length and breadth of Guyana. And courts of international physical infrastructural standing. And they have all the technological apparatus that courts across the regions or the region has. And we have appointed so many magistrates. I think 12 magistrates over the last 5 years, 11 Court of Appeal judges, and a number of High Court judges, I can't remember how many. We have not had this wave of appointments, judicial appointments and magisterial appointments, in decades. So, when we speak about Guyana on a transformative or transformational trajectory, it's Guyana on all its fronts. It's not economic advancement alone, or financial advancement, or infrastructural advancement. It's advancement in every important state of affairs in the country. And the legal sector, obviously, being one of paramount importance. As I am on this issue of domestic violence, I saw last week a magistrate sitting in a magistrate's court in Berbice find a victim of a domestic violence complaint a sum of money after that victim refused to present evidence against the alleged abuser. That person being charged with assault causing actual bodily harm, use of threatening language, and threatening behavior. Now, domestic violence is a serious problem in our country. I can speak on domestic violence for hours. I don't have the time here and now. But the state can only play a role to a certain extent. We have equipped all the police stations with domestic violence special capabilities. We have trained police officers to take how to treat with domestic violence complaints. We have put specialized vehicles and facilities in place to address domestic violence complaints at the level of the police station. We have set up homes and centers across this country to treat with domestic violence victims so that they don't have to go back into the home where the abuse is taking place if the abuser is still there. We have trained counselors and social workers across the country to treat with domestic violence victims. We have put a law in place that is of its most modern type, that the IDB just recognizes as a model law for the Caribbean. That's what the IDB is saying. That's what they've said to me personally, that they want to use our Domestic Family Violence Act as a model law for the rest of the Caribbean, because it has so many different provisions in it, both civil procedures and civil remedies, as well as criminal remedies. We have put all of that in place to tackle this deadly problem of domestic violence. Our experience has shown that domestic violence gets progressively worse, and on many occasions it ends up in death. This is not something that we take lightly. And on many occasions, the very persons who seek to make representation, the very victims that seek to make representations for and on behalf of the abuser, ends up in the long run dead, mutilated, or physically damaged in a severe way because the violence intensifies. And we, as a government, when these things happen, the law must take its course. The law must take its course. One can take into account the views of the woman or the victim, but the person must be, the abuser must be dealt with in accordance with law. Under the Act, under the Family Violence Act, if the victim condones the abuse, the victim can also be charged. If the victim refuses to testify, the victim can also be charged and penalized. What you're seeing here is a classic case of the abusive or the abused victim syndrome. She begs for the man, or he begs for the woman. If it is it's reversed, and then worse happens in short shrift. So I want to commend the approach of this magistrate. For 60,000 fine, I believe may have been too lenient. Mark my word. I'm hoping it doesn't happen. But 9 out of 10 times, this abuse will return. I'm not wishing that in anybody, but I've dealt with enough, and you know, you live in this society. You know how domestic violence unfolds. We have studied it. The victim begging for the abuser has never solved the issue, has never reduced domestic violence, has never done anything, in my view, to help the issue of domestic violence. This here is just to give another chance for greater abuse. That's what the empirical data establishes, unfortunately. We have already passed program time, and I have not even covered most of the issues that I wanted to. I don't know how time flies out when I'm on this program. I want to thank you very much for being on this program over the past hour. We have covered a number of important issues. Next week, as I said, I will not be on the program. We have the conference in Barbados that I spoke to you about. I will be attending the conference in Barbados, and there will not be any issues in the news next week. But as soon as I return the following Tuesday, obviously, we will resume our discourse. Thank you very much. Please enjoy the rest of the evening. Stay safe, and I'll see you not Thursday, not Tuesday, the following Tuesday, when we resume and we meet again. May God bless you and stay safe until then. Thank you very much.